Come on in. Get comfortable. If you're already under a blanket, that's perfect. If the lights are low and you're starting to feel that gentle heaviness behind your eyes, even better. Wherever you are right now, whatever kind of day you just had, I'm really glad you're here. Tonight, we're going back, way back, into a world that looks almost nothing like the one you live in, and yet, if you sit with it long enough, starts to feel uncomfortably familiar in ways that are hard to shake. So let me open with something that will probably stay with you. In the year 1455, in England, a 12-year-old girl was handed to a man she barely knew. She was small. Descriptions from the time say she was slight, underdeveloped, still very much a child in both body and spirit. The man was 25, twice her age. And the moment she said her vows, she stopped being just a girl with a name and a future that belonged to her. She became a wife. And everything that word meant in the medieval world, every restriction, every obligation, every quiet and not so quiet terror, closed around her like a door swinging shut. Her name was Margaret Beaufort. By the time she was 13 years old, she was a widow, 7 months pregnant, alone in a castle in Wales, with a civil war raging outside the walls and a body that the birth would nearly kill. The baby she carried became Henry VII, the first king of the Tudor dynasty. And Margaret, she went on to become one of the most powerful women in English history. Not because the world gave her anything, but because she found a way to survive every single thing it took from her.
Her story is extraordinary, but what makes it genuinely haunting is that it wasn't unusual. Not really. Tonight we're going to walk through one of the most misunderstood corners of medieval life: marriage. Specifically, what marriage meant for the women who actually lived through it. Not the fairy tale version, not the romance novel set in a candlelit castle, not the Hollywood one where the hero rides in at the last moment and everyone sighs with relief. The real thing, the legal thing, the quiet, daily, sometimes brutal thing. And I want to be honest with you from the start. This is not a simple story. It's not all darkness and suffering, but it's not all romance and roses either. The truth, as history tends to be, is far more layered, far more human, and honestly, far more interesting than either extreme. So, let's start at the very beginning, before the wedding, before the vows, before any ring. Let's start with a girl who had no idea what was coming. When I say medieval, I mean roughly the 500 years between the 5th and the 15th centuries. Across Western Europe during that time, childhood as we understand it today simply didn't exist in the same way. There was no protected, unhurried period of just being a kid, especially not for girls. From the moment a female child was born into a family of any social standing at all, she was an asset, a future contract, a piece of currency in a world where power moved through bloodlines, land, and strategic alliances. This is not me being dramatic. This is the documented reality. For noble families, a daughter's value was calculated almost immediately. What land did she stand to inherit? What bloodline did she carry? What alliances could her marriage seal? Who needed to be rewarded, pacified, or permanently bound to the family? These were the questions that determined who she would marry, when she would marry, and whether she had any say in the matter at all.
The answer to that last question, by the way, is more complicated than you might expect. We'll get there. But first, let's talk about age, because how young are we actually talking? The Catholic Church, which governed marriage law across virtually all of Western Europe during this period, set what it called the age of consent for marriage. For girls, that age was 12, for boys, 14. These were the minimums, the floor, not the ceiling. And they were based on the Church's understanding of when puberty began, which theologians of the time considered the threshold of readiness. Let that sit for a second. 12 years old. Now, to be fair to history, and I think we do have to be fair, even when it makes us uncomfortable, the Church didn't simply endorse child marriage without any caveats. There was a distinction, at least in theory, between betrothal and consummation. A girl could be formally promised in marriage years before she turned 12, but the marriage wasn't supposed to be consummated until both parties had reached the age of consent. In practice, as you might imagine, that distinction wasn't always honored, especially when money and inheritance were involved. Margaret Beaufort's story is the clearest example of what happened when it wasn't. She was born in 1443, the daughter of John Beaufort, the Duke of Somerset. Her father died when she was barely a year old, possibly by his own hand after a failed military campaign brought him disgrace at court. So Margaret entered the world already carrying weight. She was an heiress, a rich one, and in the medieval world, that made her dangerous.
A wealthy heiress was not primarily a person. She was a resource. The moment her father died, the question wasn't, how do we care for this child? The question was, who gets to control her lands and who gets to marry her? By the time she was around 3 years old, she had already been contracted in a marriage of convenience to a boy named John de la Pole, the son of a powerful duke who wanted access to her estates. They were toddlers. They had absolutely no idea what was happening. The marriage was, as historians delicately describe it, a marriage of words only. It existed on paper, not in any meaningful human sense. That arrangement was eventually dissolved, but the pattern had been set. Margaret Beaufort was a chess piece on a board where she never held any of the other pieces. When she was 9, she was summoned to court. King Henry VI himself, a frail, mentally unstable king who desperately needed to secure his dynasty, had a new plan for her. He told her she needed to marry again. He offered her 2 options. She could marry her former child husband, or she could marry Edmund Tudor, his own half-brother. And here is the small, strange, quietly remarkable part of this story. The king actually let her choose. He probably didn't mean it as any great act of generosity. He was most likely humoring a 9-year-old to make the whole process go more smoothly. But Margaret took it seriously. She asked for a night to pray and think it over. She prayed. She considered. And the next morning she told the king she would marry Edmund Tudor. She was 9 years old. She thought she was making a choice, and maybe, in the narrowest possible sense, she was. But the shape of that choice, the limits of it, tells you everything about what medieval marriage meant for a girl born into any world of consequence.
So, on the 1st of November, 1455, Margaret Beaufort, age 12, was married to Edmund Tudor, age 25, at Bletsoe Castle. He was more than twice her age. And historically, most noble families understood, even if they didn't always enforce it, that a young bride shouldn't be expected to live as a wife in the fullest sense
until she was at least 14, if not older. Her body simply wasn't ready. Medieval medicine, limited as it was, had some awareness of this. Even church law acknowledged that pregnancy in a very young girl was dangerous. Edmund did not wait. Historians have grappled with how to describe what followed. Some are diplomatic about it, others are not. What we know is that within months of the wedding, Margaret was pregnant. She was 12, possibly just barely 13. Her body was described by contemporaries as small and slight. Edmund was then captured by Yorkist forces during the Wars of the Roses. He was imprisoned at Carmarthen Castle, and while he was there, he died of plague in November 1456. Margaret was 13 years old, 7 months pregnant, a widow, alone in Wales, far from her mother, far from anything familiar, in the middle of a civil war. She made her way to Pembroke Castle under the protection of Edmund's brother, Jasper Tudor, a man who, by all accounts, was genuinely kind to her in a way her husband had not always been. And on the 28th of January, 1457, on a freezing winter night, Margaret Beaufort gave birth to a son. The birth nearly killed her. Contemporary writers described her as so little of personage, such a small frame, that neither she nor the baby were expected to survive.
She did survive. So did he. But the damage to her body was permanent. She never carried another child to term in any of her 3 subsequent marriages. 50 years later, when her own granddaughter was to be married, Margaret wrote with urgency that the girl's husband must wait, that he must not injure her or endanger her health by proceeding too quickly. She was writing from memory, from her own body's memory. That baby, born on a cold January night in 1457, became Henry VII, King of England, first of the Tudors. Now, Margaret's story is extraordinary because of everything she went on to do. The political maneuverings, the alliances, the dynasty she essentially single-handedly engineered. We won't go deep into all of that tonight, because this isn't just Margaret's story. It's the story of every woman who lived within the same system. The rules, the expectations, the walls. But her story matters as our opening window because it's documented. We have the letters, the court records, the chronicles. And those records let us see, with an unusual clarity, what the system looked like from the inside. And here's what strikes me most every time I read about her. The system was not designed to protect her. It was designed to use her. And yet, she navigated it. She bent it. She outlasted it. That tension between the constraints placed on women and the extraordinary ways some women found to exist within and around those constraints is going to run through everything we talk about in this series.
Now, you might be sitting there thinking, okay, but Margaret was nobility. She was one of the wealthiest girls in England. Surely ordinary girls, peasant girls, had a very different experience. Yes and no. The details changed dramatically based on class. A peasant girl wasn't being married off to seal a political alliance or inherit a dukedom, but she was still subject to rules she didn't write and pressures she didn't choose. For the peasant class, marriage had its own gatekeepers. Lords of the manor held authority over their serfs, and that authority extended to marriage. A female serf who wanted to marry had to ask permission from her lord, and she had to pay a fee for that permission. It was called merchant. The logic behind it was simple and cold. A serf who married might move away, might have her children belong to a different lord's estate, so the lord was owed compensation for the loss of a worker and her future offspring. She was, in the most literal sense, financially valued as a producer of children. For peasant girls, marriage also tended to come a little later than for the nobility, typically in the late teens to early 20s, not because the world was suddenly kinder to them, but because a poor family had less to gain from rushing the arrangement, and a young girl's labor was still useful to her parents before she left. This meant that, paradoxically, some peasant marriages were entered into with a slightly more practical equality. The couple often knew each other. They worked in the same fields. They had something closer to a mutual sense of each other's usefulness as a life partner. That doesn't mean love was guaranteed or that power was equal. It wasn't. But it was a different texture of constraint. The one thing that was universal across every class was this: a girl grew up in a world that was already making decisions about her future before she was old enough to understand what the future even was.
And here's what I want to leave you with as we settle into this first stretch of the story. There's a very human instinct when we look back at history like this to feel pity for these women and then move on. To say, thank goodness things are different now, and close the book. But I think Margaret Beaufort deserves more than pity, and so does every other woman we'll meet in this series. Because within a system that treated them as assets, as contracts, as tools of inheritance, they thought, they felt, they loved and grieved and strategized and endured, and sometimes, quietly, triumphantly, they won. Margaret didn't just survive that cold night in Pembroke Castle. She spent the next 30 years working with extraordinary patience and intelligence to put her son on the throne of England. She didn't do it because the world gave her the tools. She did it with whatever the world had left her after taking almost everything else. That's not a story about helplessness. That's a story about what a person can do when the only move available is forward. So now that you know how a girl entered the medieval world of marriage, young, with very little say, and often with a great deal of weight already pressing down on her before she ever spoke a vow, let's talk about what happened the moment a marriage was actually being arranged. Because here's the thing nobody tells you in the history books. Before any two people in the medieval world walked down an aisle, or more accurately, stood in a church doorway, there were weeks, sometimes months, of something that looked a lot less like romance and a lot more like a business merger. There were meetings, there were documents, there were men sitting across tables from each other, sometimes with lawyers, sometimes with priests, sometimes both, going through line by line what each family would give, what each family would receive, and what the woman standing at the center of it all was actually worth. And the answer to that last question was remarkably specific. Let's start with the dowry, because almost everyone has heard the word, and almost nobody fully understands what it actually meant. A dowry was not a gift to the bride. I want to say that again, because it's such a common misunderstanding. A dowry was not given to the woman, it was given with the woman.
It passed from her family, her father, her guardian, whoever held authority over her, directly into the hands of her husband. Think of it as the price of admission. The bride's family was effectively paying the groom to take their daughter, and in exchange, the groom gained control of everything she brought with her: land, money, livestock, household goods, sometimes entire estates. The woman herself walked through that transfer like a parcel attached to its contents. Now, I know that sounds brutal, and it was, but it also had an internal logic that medieval society took very seriously. Marriage in this world was not primarily about two people building a life together. It was about two families combining resources and obligations. It was a legal contract with enormous consequences for inheritance, for land control, for political power. The dowry was the bride's family's contribution to that contract. In wealthy households, dowry negotiations could last for months and involve some of the most complex financial planning of the entire medieval era. Historians who've studied surviving marriage contracts from England and France describe them as resembling something close to modern property law agreements. Every asset was catalogued. Every contingency was discussed. What happens if she dies before he does? What if he dies first? What if there are no children? Nothing, at least in theory, was left to chance.
And this is where the second piece of the puzzle comes in. The piece that gets far less attention. The dower. If the dowry was what the bride's family paid out, the dower was the husband's obligation back, often declared at the church door, in front of witnesses, at the very moment of the marriage. The groom was required to formally set aside property for his wife in the event of his death. In English common law, this was standardized at 1/3 of the husband's lands. Not a gift, not a courtesy, a legal right. If the husband died, the widow was entitled to 1/3 of everything he had held during their marriage for the rest of her own life. This mattered enormously. In a world where women couldn't work in most professions, couldn't hold most public offices, and had very few independent means of support, the dower was quite literally the difference between survival and destitution. Now, can we talk about Eleanor of Aquitaine for a moment? Because there is no better illustration of what a dowry could mean and what it could do to a woman's life than her story. Eleanor was born around 1122. Her father was William X, Duke of Aquitaine, ruler of one of the wealthiest, most culturally vibrant regions in all of France. Aquitaine was not just land, it was power. It controlled vast wine-producing regions, major trade routes, and the loyalty of countless noble families. It was, in the estimation of contemporaries, more or less the jewel of Western Europe.
And Eleanor was the heir to it all. Her father died when she was around 15. In that single moment, Eleanor became the most desirable marriage prospect on the entire continent. Every king, every duke, every ambitious nobleman with even a passing awareness of geography understood what her dowry represented. The French king, Louis VI, known as Louis the Fat, which doesn't seem particularly diplomatic, but there we are, moved faster than anyone. He arranged the marriage of Eleanor to his son, the young prince who would become Louis VII, within 40 days of her father's death. 40 days. The negotiations that secured the future Queen of France happened in barely more than a month. Eleanor's dowry was Aquitaine itself, the entire duchy. She walked into that marriage bringing more territory than most kings held in their own names. And here is the extraordinary, almost painful irony. All of that land passed immediately into the control of her husband. Eleanor, who had inherited this vast domain, who had been its duchess in her own right, who knew its people and politics better than anyone, became legally unable to exercise direct authority over it. The moment she said her vows, the land was hers by birth, but the marriage made it his by law. Their marriage lasted 15 years. It was not, by most accounts, a happy one, though happiness was never really the point. They went on the Second Crusade together, which was a catastrophic military failure. They disagreed constantly on matters of governance. They had 2 daughters, but no sons, which was, in the diplomatic language of the time, a problem.
And then Louis did something that many medieval noblemen might have considered deeply unwise. He agreed to an annulment. The official reason was consanguinity, the claim that Eleanor and Louis were too closely related by blood for the marriage to be valid under church law. The actual reason was considerably more complicated and probably involved the genuine breakdown of their relationship and the relentless pressure to produce a male heir. The annulment was granted in 1152. Eleanor walked away from that marriage with her lands returned to her. That was the deal. Aquitaine came back to her, personal control, the moment the marriage ended. And Eleanor, free for perhaps her first time in her adult life, moved with extraordinary speed. Within 2 months of her annulment from the King of France, she married again. Her new husband was Henry, Count of Anjou, a man 11 years younger than her, brilliant and ruthless, who would soon become Henry II, King of England. With that second marriage, Eleanor's dowry, Aquitaine, transferred once again, this time to the English crown, and the consequences of that transfer echoed through European politics for literally 300 years. Aquitaine remained technically and very contentiously English territory until the end of the 100 Years' War in 1453. Think about that for a moment. One woman's dowry, one marriage negotiation, and the border dispute it created lasted 3 centuries. Now, pause and ask yourself something genuinely worth sitting with tonight.
Does this seem entirely different from the world you live in? On the surface, yes. Obviously, women today are not delivered to husbands with their property attached. Marriage is not a financial contract requiring documented land transfer at the church door. But the underlying question, what is a woman worth and who controls the answer, that question didn't disappear. It just changed its costume. It became salary gaps, inheritance patterns, the default assumption that a woman's assets become household assets in a way that a man's often don't. The medieval dowry system was extreme in its openness. It said the quiet part loudly. And sometimes the loudness of it is actually useful because it lets us see the logic underneath with unusual clarity. Let me bring us back down from the royal level, though, because Eleanor of Aquitaine is extraordinary precisely because of the scale. Most women's stories played out in the much smaller, much quieter space of ordinary dowry transactions. A farmer's daughter might bring a cow and a small plot of land. A merchant's daughter might bring a sum of money and a set of household goods. Even a woman with very little brought something, because arriving empty-handed reflected on the honor of her family. Historians who've studied English manor records from the 13th and 14th centuries have found accounts of dowry negotiations involving a single sheep, a wooden chest, a loom, a season's worth of grain. These were not political transactions. They were the careful, anxious calculations of families doing the very best they could to set a daughter up for a life she could not easily leave once she entered it. And in every single one of those transactions, large or small, the same essential structure held. The bride was the center of the negotiation and the least powerful person in the room. She didn't write the contract. She didn't hold the land after it was signed. She didn't get to walk away if the terms didn't suit her. What she got, if the negotiation went well, was a dower she could someday rely on. A guaranteed third of her husband's estate, sitting in the future like a promise, conditional on his death, conditional on her outliving him, conditional on no one contesting her rights after he was gone.
It was, in every sense, a life built on contingency. There's one more layer to this financial architecture worth spending a moment on, because it's genuinely strange and a little heartbreaking when you understand it fully. The dowry a woman brought into marriage was not hers to manage. It belonged to her husband. But, and here's the strange part, if the marriage ended or if he died, the dowry was supposed to return to her family, not to her, to her family. So a woman could spend 15 years in a marriage funded partly by assets her own father had assembled for her, assets listed in the marriage contract under her name, have no personal access to them for the entire duration of that marriage, and then, if the marriage ended, watch them go back to the family she had left rather than remain in her own hands. She was, in the most technical sense, a conduit, a legal channel through which assets moved from one family of men to another family of men, with a brief stop in the household she ran but never fully owned. And yet she ran that household. She managed its accounts, its staff, its stores, its relationships with the wider community. She made 1,000 small decisions every day that kept the whole structure functioning. She was, in effect, the operating system of the medieval household, indispensable, constantly running, and almost entirely invisible in the official record. We're going to spend a lot of time looking at what happened inside those households, the daily texture of married life for medieval women, the work, the relationships, the negotiations that took place not in legal documents, but over dinner tables and in quiet rooms. But first, we need to understand something that might be the single most surprising fact about medieval marriage law, something that cuts directly against the image of absolute control and rigid arrangement. Because here is what most people don't know. Under the law of the Catholic Church, which governed marriage across the entirety of Western Europe during this period, there was one thing, one specific and precise thing that no father, no king, no lord, no amount of money could legally provide without the woman's direct involvement: her consent. What that meant in practice, and the enormous, complicated, sometimes heartbreaking gap between what it meant in theory and what it meant in lived reality, that's exactly where we're heading next. So, we left off with a promise, and I want to honor it, because this is genuinely one of the most surprising things I've ever come across in medieval history. We talked about the money, the dowries, the negotiations, the extraordinary financial architecture that surrounded a medieval marriage. And right at the end, I mentioned that underneath all of it, underneath the contracts and the land transfers and the fathers sitting across tables from each other, there was one element of marriage that no amount of money could fully replace: consent. And I meant it when I said it would surprise you.
because the story of what consent meant in the medieval world, how it worked, who it protected, and what happened when people figured out how to use it is not the story most people expect. It's honestly a little bit like finding out that the most controlling, rigid institution you can imagine accidentally created the world's greatest loophole. So let's go back to the 12th century. Around the year 140, a monk and legal scholar named Gratian, working in Bologna, Italy, produced a document that would reshape the legal landscape of Western Europe. It was called the Decretum, an enormous, ambitious attempt to collect and harmonize centuries of contradictory church law into a single coherent framework. And in the middle of this vast legal text, Gratian turned to marriage and asked what seems like a simple question. What actually makes a marriage? Not what makes it beautiful, not what makes it legitimate in the eyes of the community. What makes it legally, spiritually, unbreakably real? His answer was radical for its time, and it had consequences that rippled through European society for the next 300 years. Consent, Gratian argued, is what makes a marriage. Not the dowry, not the ceremony, not the priest, not the parents, not the lord of the manor, or the king, or anyone else. He wrote, and these words were copied, debated, and built upon by legal scholars across Europe, that no woman should be married against her free will. He went further. Those who are to be of one body, he said, ought also to be of one spirit, and therefore no woman who is unwilling ought ever to be joined to anyone. Let me be clear about what this meant in context. This was not a revolutionary pamphlet being handed out in the streets by reformers. This was official canon law, the official legal doctrine of the Catholic Church, written by a legal scholar whose work became required reading in every major university in Europe. In the eyes of the Church, if a woman did not genuinely consent, she was not married. Full stop. Now, before you get too comfortable with that, I want to be very clear about two things. First, the gap between what the Church declared in law and what actually happened in practice was often enormous. A woman could technically refuse, but the social, economic, and physical consequences of refusing could be devastating. We'll get to that. Second, the way consent worked in practice was far stranger, far more anarchic, and honestly far more interesting than you might imagine. Because the thing about declaring that consent alone makes a marriage is that it immediately raises a question nobody in 1140 had fully thought through. If all you need is two people to say yes to each other, what happens when they say it in secret? This is where medieval marriage law gets genuinely, wonderfully complicated. By the 12th century, the official church position, built on Gratian's framework and refined by Peter Lombard, the Bishop of Paris, who added the crucial detail about words spoken in the present tense, was essentially this. If two people of legal age stood face to face and said to each other, in present tense words, "I take you as my husband, and I take you as my wife," they were married. No priest required, no witnesses required, no church building required, no parents, no ceremony, no banns read aloud on 3 consecutive Sundays, no feast, no documentation, just two people, 2 sentences spoken aloud, and according to the highest legal authority in Western Europe, that was an indissoluble, permanent, valid marriage. Peter Lombard made the distinction even more precise because medieval canon lawyers loved nothing more than a very specific technicality. He explained the difference between verba de futuro, words in the future tense, meaning a promise to marry, and verba de presenti, words in the present tense, meaning I am marrying you right now. The first was a betrothal, the second was a marriage. And the difference between saying I will take you and I take you was legally the difference between a promise and a fait accompli. I take you. 2 words, and nothing on earth, in theory, could undo it. You can probably already see where this is going. And yes, people noticed almost immediately.
The ecclesiastical courts of England, France, the Low Countries, and across Western Europe began filling up with cases. Hundreds of them, thousands of them over the following centuries. Cases in which someone claimed a secret marriage had taken place. Cases in which someone denied it. Cases where a woman came to court saying a man had promised her marriage and then walked away. Cases where a man tried to escape a public marriage to a woman he didn't want by claiming he was already secretly married to someone else. Historians who have studied the records of the ecclesiastical court at York, one of the largest surviving collections of medieval marriage litigation in England, have found case after case involving what were called clandestine marriages, secret marriages. Marriages made in gardens, in bedrooms, at the sides of roads, in taverns, under trees. Couples who exchanged vows in all of these places and more. And because the law said 2 present tense sentences were enough, the church was required to take every single one of these cases seriously. Think about what this actually meant for a woman. And I want to be careful here because the implications cut in 2 directions at once. On one hand, this was a form of protection. A woman who genuinely wanted to marry a man her family disapproved of had, in theory, a tool. She could simply say the words in private, without witnesses if necessary, with the man she chose, and legally she was married. Her family could scream, her lord could object, her father could disinherit her, but the marriage was valid under church law. This actually happened. Documented cases exist. Joan of Acre, the daughter of King Edward I of England, secretly married Ralph de Montermer, a squire in her own household, a man far below her rank, after the death of her first husband. When her father found out, he was, as one chronicler diplomatically put it, not amused. He had Ralph imprisoned, but Edward eventually had to accept the marriage because it had been validly contracted. His own daughter had used the system against him.
Catherine of Valois, the widow of King Henry V of England, secretly married a Welshman named Owen Tudor, a man of far lower station whom she loved, rather than remain a widow subject to restrictions on her remarriage. That secret marriage, contracted quietly and without any of the ceremony her status would have demanded, ultimately produced a line of descendants that included the entire Tudor dynasty. In both cases, a woman, a choice, 2 sentences, and a system that, however reluctantly, had to honor it. But now the other direction, and this is where I want you to sit with some discomfort, because the same law that protected women who wanted to make secret choices also made them vulnerable in a way that is genuinely difficult to absorb. If all you needed were 2 people saying, "I take you," in present tense words, and no witnesses were required, then a man could claim a woman had consented to marry him privately with no one else present, and she had almost no way to definitively disprove it. All he had to say was, "She said the words, it was just the 2 of us." And if she had been alone with him at any point, if there had been any intimacy between them, if anyone could be found to testify that they'd been seeing together,
the court was forced to at least consider the possibility that a marriage had taken place. Historians studying these cases have found women who came to ecclesiastical courts insisting they had never agreed to marry the man claiming her as his wife, and some of them won their cases, but many did not, because in a legal framework built on the premise that two private words created a permanent bond, and in a world where a woman's word against a man's word was already an uphill battle, the same legal structure that gave women one kind of freedom could also be used as a trap. Now, I want to tell you about a case that illustrates all of this better than any abstract legal principle ever could. And it's a case that changed the course of English history. The year is 1464. England is in the middle of the Wars of the Roses, that bitter and exhausting civil conflict between the houses of Lancaster and York. The young Yorkist king, Edward IV, is 22 years old, recently crowned, and supposed to be negotiating a diplomatic marriage to a French princess that will cement England's alliances abroad. Instead, he secretly married a widow named Elizabeth Woodville. The secrecy alone was scandalous. A king marrying without the knowledge of his council, without any diplomatic negotiation, without any of the public ceremony that royal marriages demanded. This caused an immediate uproar. But it was, by the Church's definition, entirely valid. They said the words, they consummated the marriage. Done. Here is where it gets truly extraordinary. Years later, after Edward had died and his young son was about to be crowned Edward V, a bishop named Robert Stillington came forward with a claim. He said he had evidence that Edward IV had previously, before his marriage to Elizabeth Woodville, made a secret marriage contract with another woman, a noblewoman named Eleanor Butler, daughter of the Earl of Shrewsbury. If that prior secret marriage had taken place, and Stillington claimed he personally witnessed the exchange of vows, then Edward IV had been a bigamist. His marriage to Elizabeth Woodville was not just irregular, it was invalid, and their children, including the young boy about to be crowned king, were illegitimate. Parliament accepted the claim. The two young princes were declared illegitimate. Edward's brother Richard took the throne as Richard III. Eleanor Butler had died in 1468, years before any of this became public. She could not testify. She could not deny it or confirm it. She was simply gone. And in her absence, the memory of two people speaking private words in a room somewhere had the power to reshape the English succession. Whether Stillington's testimony was true, whether that secret marriage had actually occurred, or whether it was a political fabrication used to justify Richard's seizure of power, historians have argued about for more than 500 years. It remains one of the great unanswered questions of English medieval history.
But here's what the story tells us, regardless of the answer. In a system where two words spoken in private constituted a permanent marriage, the stakes of secrecy were almost unimaginably high for everyone, including kings. There's something genuinely moving about all of this, if you stay with it long enough. The Church, in trying to protect women from forced marriages, created a law that said consent was everything. The heart was the seat of the will. No one could force a yes. And that principle, however imperfectly enforced, however easily abused, was a remarkable thing to enshrine in law in the 12th century. It wasn't feminism. It was theology.
but it had feminist consequences, at least in flashes. A girl who found her way to a church court and said clearly, without wavering, that she had never consented. Sometimes she won. Sometimes the law worked. And the fact that it sometimes worked, in a world structured almost entirely against women's legal autonomy, is worth sitting with for a moment. Of course, the reason it didn't work more often brings us to a harder truth. Because consent in the medieval world existed on a spectrum, and at the darker end of that spectrum was the uncomfortable reality that pressure, family pressure, social pressure, fear of poverty, fear of something worse, could shape a woman's yes in ways that made it very hard to call it freely given. What the law said and what the human experience actually felt like were often two entirely different things. That gap between the letter of the law and the lived reality of women inside medieval marriages is something we're going to sit inside for a while. Because right now we've talked about how women entered marriage, we've talked about the money surrounding it, and we've touched on the surprising legal principle at its heart, but we haven't yet talked about what happened the moment the ceremony was over. The moment the words were spoken, and the vows were made, and the feast was eaten, and the guests went home. The moment a woman crossed a threshold and became, in the eyes of the law, something she had not been the day before.
What that transformation actually meant, what it cost, what it erased, and what, in certain very specific circumstances, a woman could still hold on to. Picture this moment. A woman stands in a doorway. Behind her, her family's house, her name, her legal self, everything she has been for however many years she has lived. In front of her, her husband's home, his name, his world. She steps across that threshold, and in the eyes of English common law, the woman who walked in no longer exists. This is not a metaphor. This is not me being dramatic for effect. This is what the law actually said. From the 13th century onward, when a woman married under English common law, she underwent what legal historians have called, with striking precision, a kind of civil death. Her separate legal identity didn't diminish, it didn't shrink, it was absorbed, swallowed whole into the legal person of her husband. The doctrine had a name. It was called coverture, and the name tells you everything. She was covered, hidden, folded inside him like a letter sealed in an envelope. The outside bore his name. She was the contents, real, present, essential, but invisible to anyone who wasn't prepared to open the seal. The legal scholar Henry de Bracton, writing in the 13th century in what became one of the most influential legal treatises in English history, put it plainly. Husband and wife, he wrote, were a single person, one flesh, one blood. The legal personality of the wife became merged in that of her husband. She took his name. She was, in the words that would be echoed down through centuries of English law, no longer a legal entity. The French term used in medieval English legal courts for a married woman was femme couverte, literally a covered woman. The term for an unmarried woman or a widow was femme sole, woman alone. And here's the extraordinary, almost darkly funny thing about those two designations. Femme sole, woman alone, was actually the freer one. Being alone in the eyes of this legal system meant you existed. Being covered, being married, being protected by a husband, that meant you had legally disappeared. William Blackstone, the great English legal commentator writing in the 1760s, crystallized this idea in language that is worth sitting with. He wrote that upon marriage, the very being or legal existence of the woman is suspended, not restricted, not limited, suspended. like a breath held, like a clock stopped. And then he added the line that has been quoted by historians, lawyers, and everyone who has ever studied this subject, because it captures the logic of the whole thing with such devastating tidiness. By marriage, the husband and wife are one person in law. And that one person, that singular, unified legal entity, is the husband. As a later American jurist put it even more bluntly, though the husband and wife are one, the one is the husband. Now let me tell you specifically what this meant, not in abstract legal terms, but in the actual daily practical texture of a woman's life once she was married. She could not own property, not in her own name. Anything she brought into the marriage, land, money, jewels, household goods, the dress she was wearing on her wedding day, became, upon marriage, the legal property of her husband. He could sell it, he could give it away, he could gamble it if he chose. She had no independent claim to any of it. She could not sign a contract. She could not enter into any legal agreement on her own behalf, because she had no legal self to bind. If she wanted to buy something, sell something, make any kind of formal arrangement, her husband's involvement, his authority, his signature was required. She could not sue. She could not appear before a court as an independent party. If she had been wronged, if someone had cheated her or damaged her property or broken a promise to her, she could not bring a case. Her husband brought it on their behalf, because legally it was his injury. And she could not write a will. A married woman making a will was, from the perspective of common law, something close to a legal impossibility, because everything she might wish to leave to someone had already been transferred to her husband the moment she said her vows. She had nothing in her own name to bequeath. Historians studying probate records from medieval England have found that the number of wills made by married women drops off sharply compared to those made by widows, who had re-entered femme sole status and regained the legal ability to own and dispose of property. Think about what that means in human terms. A woman could live for 30 or 40 years as a wife, managing a household, raising children, conducting all the daily business of a complex domestic life, and not be able to write down what she wanted to happen to her possessions after she died. Because legally, she didn't have possessions. She hadn't had possessions since the day she married. There's a detail in this that I keep coming back to because I find it particularly illuminating. Under English coverture, even the clothes on a woman's back, the gown she wore, the jewelry she kept in a small box, the personal items of everyday life, technically belonged to her husband. Some legal commentators of the period noted that a wife might have a kind of customary claim over her own clothing and personal adornment. Bracton himself mentioned that a wife could be said to have something of her own in the items given to her for personal adornment. But this was a courtesy, not a right. It existed in practice, not in law. And the distinction between practice and law when a marriage went wrong was everything. Now, does this mean every medieval husband marched around demanding formal legal control over his wife's hairpins? Obviously not. Plenty of medieval marriages operated with genuine mutual cooperation. Husbands who trusted their wives' judgment, wives who exercised substantial practical authority within the household and beyond it. The letter of the law and the reality of daily life were often two very different things. Historians who've spent careers studying this period are careful to remind us that the gap between legal doctrine and lived experience was real and significant. But here's the problem with that gap. The moment things went wrong, the moment trust broke down, the moment a husband died and his heirs disputed what his widow was owed, the law is what won. The practice disappeared. The letter of coverture remained. And it's in those moments, the contested moments, the crisis moments, that you see what the system actually was. Let me give you a human example that illustrates this with unusual clarity. Sometime in the late 13th century, a woman whose name appears in the records as Joan, a widow who had been married 3 times, which was not unusual given the mortality rates of the period, found herself in a legal battle that consumed years of her life. Her 3rd husband had died. The property she believed was rightfully hers, property she had brought into that marriage, property she had managed and maintained, was being claimed by others.
She petitioned the king. She fought in courts. She documented her case with letters and arguments that showed, by any reasonable reading, that she understood the law better than most men of her time. And she fought, and she pushed, and she partially won. Not because the system was designed to help her, but because she was formidable enough, stubborn enough, and legally literate enough to work the system from within. Her story is not unique. The records of equity courts and chancery courts, the courts that operated outside the strict common law and could take a somewhat more flexible approach, are full of women doing exactly this: petitioning, arguing, finding the small spaces where the system could bend, and pushing. But here's what always strikes me: the fact that it required this level of effort. The fact that a woman who was plainly in the right had to spend years fighting for what a man in the same situation would simply have had. The fact that working the system from within was itself a form of labor, exhausting, costly, uncertain, that women were expected to perform while also running households and raising children and managing estates. Now here's where the story becomes genuinely interesting in a different way, because coverture, as total as it sounds, was not actually uniformly applied, and the exceptions, the cracks in the doctrine, tell us something important about how medieval society actually functioned. The most significant exception was something called femme sole status in trade. In certain English towns, London being the most prominent example, married women who conducted business independently of their husbands could, under local custom, be legally recognized as acting as if they were single. They could sign contracts for their trade, they could sue and be sued in matters related to their business, they could conduct commerce with a legal identity. The logic was entirely practical. The London wool trade, the textile merchants, the market stalls, the medieval urban economy, all of it depended on women being able to buy and sell, and a system in which every transaction a woman made was void because her husband hadn't personally authorized it would have been commercially catastrophic. So the law bent. In the specific, limited context of trade, a married woman could exist as a legal person. And I find this fascinating. The system was not completely rigid. It had pressure valves, and those pressure valves tell you what medieval society actually valued enough to protect. Not women's autonomy as a principle, commerce. The economy needed women to function as traders, so the law made a space for them to do so.
It was pragmatism masquerading as a concession. There's another exception worth knowing, and it comes with a slightly darkly comic edge. Under the common law doctrine of coverture, a wife's crimes were generally considered her husband's responsibility. The reasoning was the same unity of person logic. If they were one person, and he was that person, then her actions were his actions, and his liability extended to her actions. The practical consequence was that a wife who committed a crime in the presence of her husband could sometimes argue in court that she had acted under his compulsion, that she was merely the instrument of his will, that because the law had already established her as legally subordinate to him, it wasn't unreasonable to presume that anything she did in his presence was something he had directed. This defense actually worked in some cases. Not always, not reliably, but sometimes.
Which means, and I want to be precise about this, that the very doctrine designed to erase women's independent existence occasionally served as a bizarre form of legal shield. If you had no will of your own in law, how could you be held fully responsible for your actions? I'm not suggesting this was anything resembling justice, but it's a reminder that complex systems produce unpredictable edges, and medieval women were often very skilled at finding those edges. I want to pause here and ask you something genuinely, and I mean this as a real question worth thinking about tonight as you drift off. We live in a world that has formally rejected all of this. In most countries, women have full and equal legal personhood, whether married or not. The doctrine of coverture was dismantled piece by piece through the 19th and 20th centuries. In England, the Married Women's Property Act of 1882 was the crucial turning point, the moment when married women were finally recognized as being able to own property in their own names. In the United States, some aspects of coverture survived in certain states into the 1960s. Not the 1360s, the 1960s, within living memory. And even now, even after the formal legal abolition of all of this, historians point to remnants, the cultural expectation that a woman takes her husband's name, the patterns in property, wealth, and financial independence that still follow gender lines in ways not entirely explained by individual choice, the social structures that, even without a law to enforce them, still carry some of the shape of the world that coverture built. I'm not saying the modern world is medieval. It isn't. The change has been real and significant, and hard-won by generations of people who refused to accept it. But I think it's worth knowing where the shape of certain assumptions comes from. History doesn't just belong to the past. It lives in the bones of the present. What I find most remarkable about the women who navigated the world of coverture, medieval and early modern alike, is not that some of them suffered under it, though many did. It's that some of them, against remarkable odds, found ways to operate within it that gave them genuine agency. They knew the law, often better than the men around them expected. They made careful use of the equity courts. They negotiated marriage settlements that protected certain assets from coverture entirely. They ran businesses under femme sole status in trade. They built networks of allies and relationships that gave them informal authority the law refused to recognize. They were, in other words, extremely competent people doing extremely difficult things in a system that was not built for them. And that competence, that daily, quiet, largely invisible labor of navigating a world designed around other people's convenience, is something I want us to carry into everything that follows. Because next, we move into a part of this history that has been whispered about for centuries, but rarely examined directly.
We've talked about what happened to a woman legally when she married. Now we need to talk about what was expected of her body. In the most intimate and specific terms, the medieval church was prepared to legislate, and the rules were, I promise you, more detailed, more strange, and more revealing about how medieval society understood marriage than almost anything else we've covered. So take a breath, settle in a little deeper, and stay with me. There's a question I keep turning over in my mind, especially after everything we've been discussing: the money, the law, the vanishing legal self. It's a question that sounds simple but is actually quite loaded. Did any of these women ever fall in love? And if they did, what on earth did they do with it?
Because here's the thing that often gets lost in the bigger structural story of medieval marriage. The human heart does not follow legal frameworks. It never has. And medieval people, despite the negotiations and the contracts and the doctrine of coverture, were still people. They felt things. They hoped. They pined. They loved. Or at least something they called love. But love in the medieval world was a far stranger and more complicated creature than the one we know today. Let's start with what might be the most quietly shocking truth about love and marriage in the medieval era. Not shocking because of its dark, but shocking because of how casually the medieval world accepted it as obvious. The church, which governed marriage and its purposes with extraordinary specificity, officially recognized two valid reasons to enter a marriage. Two. The first was to avoid the sin of sexual relations outside of marriage. In other words, to channel desire into something the church would tolerate. The second was to produce children. That was it. Those were the church's reasons, and neither one of them is love. In the 12th century, 3 more acceptable motives were added to the list: the reconciliation of enemies through strategic union, financial gain, and beauty. And I want to pause on that for a moment, because beauty is the closest thing on that entire list to anything resembling an emotional pull toward another person, and it sits at number 5, 5th place, behind avoiding sin, having children, making peace between warring families, and money. Love, genuine, freely chosen romantic love, was not on the list.
Not because people were unaware of it. They absolutely were. But because the church, which had spent considerable intellectual energy thinking about marriage, had collectively decided that love was not a reason to marry. It was, at best, something that might develop afterward, a bonus, a grace if you were fortunate, never a prerequisite. And for noble women especially, the women whose marriages carried the most political and financial weight, this was not a philosophical abstraction. It was the operating reality of their lives. And yet, at the exact same moment that the church was listing its 5 acceptable reasons to marry, none of which included love, something else was happening in the courts of southern France that would change how Europeans thought about romantic feeling for the next 800 years. The troubadours were beginning to sing. The troubadours were poets and musicians, mostly of noble birth, who emerged in the courts of Aquitaine, Provence, and Champagne in the late 11th and 12th centuries. They sang about love, but a very specific, very stylized kind of love. The French called it fin amour, which translates roughly as refined love. Later writers would call it courtly love. And a central feature of this love, the thing that defined the entire tradition, was this: it was almost never about marriage. The troubadour's beloved was typically a woman of higher status, often already married, who was idealized, worshipped from a respectful distance, and served with absolute devotion. The knight or poet suffering in her name was not supposed to possess her. He was supposed to pine for her, to improve himself in her honor, to become more virtuous, more courageous, more worthy, not in order to win her, but because loving her, even hopelessly, made him a better man. This was, if you think about it, a perfectly calibrated response to a world in which marriage and love operated in entirely separate spheres. Noble families married for power and land. Nobody expected the people involved to be in love. So where did all that human longing go?
Into poetry, apparently. Into songs about suffering knights and inaccessible ladies, and love that was noble precisely because it could never be fully had, which is either very romantic or very convenient, depending on how you look at it. Now, what did women think of all this? This is the question that almost nobody in the medieval period bothered to record systematically. The inner experience of the women who were simultaneously the objects of courtly love poetry and the subjects of arranged marriages and the legal non-entities of common law. What did it feel like to be the lady on the pedestal, the married noblewoman being serenaded from a respectable distance, while also being the same person who had been handed to a husband for dynastic reasons and had no legal identity outside his name? We have one answer, and it comes from one of the most remarkable women of the entire medieval period. A woman whose story is, if I'm being honest, one of my absolute favorites in all of medieval history. Her name was Christine de Pizan. She was born in Venice in 1364, but grew up in Paris after her father, a physician and astrologer, was appointed to the French royal court. She was educated to an unusual degree for a woman of her time. Her father actively encouraged her studies, even when her mother apparently thought the whole enterprise was unnecessary and that Christine should be learning to spin, which, honestly, fair enough from the mother's perspective, given the world she lived in. But the father prevailed. In 1379, when she was 15 years old, her father arranged her marriage to a man named Etienne de Castel, a notary and royal secretary 9 years older than Christine, educated at the University of Paris. This was an arranged marriage in the most conventional sense. Christine did not choose Etienne. Her father chose him for her. And then, in one of those small, quiet moments that history sometimes hands us, they fell in love. Not dramatically, not in the way the troubadours sang about, not the aching, impossible love of the poetry that surrounded them at court. Something warmer and more ordinary and more real than that. Christine described their marriage in her own writing as genuinely happy. Etienne encouraged her studies. He supported her intellectual life. He was, in her own words, her true friend. They had 3 children together, and for 10 years Christine de Pizan was simply a married woman who loved her husband and was loved in return. She was 25 years old when Etienne died of plague in 1389 while traveling with the royal court. Christine was left with 3 children, a widowed mother and a niece to care for, and a web of lawsuits over her late husband's unpaid salary. She had no income, no male relatives in France,
and no obvious means of supporting anyone. The system that had organized her entire life, the one in which her father found her a husband and her husband provided for the family, and her role was to manage the household and be a good wife, had collapsed, and the system offered her almost nothing. So Christine did what almost no woman of her time had ever done before. She started writing professionally, not as a hobby, not for pleasure, as a job. She wrote poems and ballads on commission for noble patrons. She wrote histories, political treatises, philosophical texts. By 1400, she had become the most celebrated writer in France, man or woman. She was offered positions at the courts of England and Milan and turned them down because she loved Paris and didn't want to leave. She wrote extensively about women, about the gap between how women were depicted in literature as fickle, weak, dangerous, morally questionable, and how women actually were, in her observation, capable, intelligent, virtuous, often heroic. Her book, The Book of the City of Ladies, written in 1405, was a direct challenge to centuries of misogynistic writing. She imagined a city built entirely of the stories of great women, biblical, historical, mythological, and invited her readers to consider what civilization owed to people it had systematically undervalued. And here's where she connects back to our theme, because Christine had very specific things to say about courtly love, and they're worth hearing. She thought it was, in her characteristically direct way, largely a trap. In her writing, she warned women about the men who placed them on pedestals. A woman who accepted the courtly love devotion of an admirer, Christine argued, might feel flattered to be idealized, but the idealization was temporary. The moment the knight succeeded in any real intimacy, the moment the pedestal collapsed, she would be ruined. Her reputation would be gone. The man would move on, and she would be left with the consequences. Christine was not cynical about love itself. She knew what real love looked like. She had experienced it with Etienne. What she was cynical about was the use of romantic language as performance, as manipulation, as a cover for something that was really about men's desires and women's reputations being traded against each other. I find that observation remarkable for 1405. She was pointing at something genuinely subtle and genuinely true about the difference between love as it appeared in literature and love as it functioned in a woman's actual life. Now, let me bring in a broader perspective here, because Christine's experience was exceptional in its detail, but not unique in its emotional shape. The question of whether love and marriage could coexist in the medieval world is not a simple one. Among the nobility, as we've discussed, marriage was primarily strategic. Love was not expected and often not present, at least not at the beginning. But that doesn't mean it was always absent. What historians have found in reading the private letters, the wills, the personal documents of medieval married couples is something more nuanced than either all arranged marriages were loveless or love was just like it is today. Many couples who began as strangers did, over time, develop genuine tenderness and partnership. Men left wills expressing profound grief at the prospect of leaving their wives. Women spoke of husbands with evident feeling. The formal language of legal documents occasionally cracks open to reveal something very human underneath. Among ordinary people, the peasant farmers, the tradespeople, the urban workers, marriage operated differently. Without land dynasties to protect and political alliances to cement, there was more room for individual inclination. Historians studying peasant marriage records have found that many couples in the medieval period seem to have known each other before marriage, to have lived in the same communities, to have made choices based at least partly on personal preference. The system still had its gatekeepers, but the emotional texture was often closer to what we might recognize as two people deciding they wanted to build a life together. And then there's this question, worth asking directly. Is love in an arranged marriage inherently compromised? I don't think the answer is yes. I think the medieval world actually proves that love, real, lasting, transformative love, can grow in conditions that look from the outside nothing like its ideal environment. Christine de Pizan and Etienne de Castel did not choose each other. And yet, by every account we have, what grew between them in 10 years of marriage was the real thing. What I find moving about Christine's story is not just the love, but what she did after it ended. She picked up the pieces in a system that had no interest in supporting her, and she made something extraordinary out of them. She turned her grief into work, her work into influence, and her influence into a defense of every woman who had been underestimated by the world she lived in. She became a writer because she had no other choice, and she became one of the great voices of medieval Europe because she was, as it turned out, astonishingly good at it.
If that's not a story about the unexpected power that grows in constrained lives, I honestly don't know what is. There's one more layer to this worth sitting with before we move on. We've talked about love within marriage and love outside it through the courtly love tradition. But there's a category of feeling that medieval people experienced in marriage that doesn't fit neatly into either. Something that might be called companionship or partnership, or the quiet accumulation of shared life. In the historical records, you find traces of it everywhere once you know to look. A husband who writes in his will that he wants his wife to manage his estate because she knows it better than anyone. A woman who travels hundreds of miles to negotiate on behalf of her imprisoned husband because she is the one who understands the law well enough to argue it. A couple who, according to the records, took every long journey together when it would have been easier for him to go alone. These are not dramatic love stories. They don't read like troubadour poetry, but they are something real and something durable that marriage, even when it began without love, could sometimes produce. The medieval world was not a romantic world by the modern definition, but it was absolutely a human one, and human beings placed in proximity, given shared purpose, tested by the same difficulties, they build bonds, they rely on each other, they grow attached in ways that can be difficult to distinguish from the inside from love. What comes next is a harder question, because we've been talking largely about what marriage could be at its most functional, most human, most livable. But the history of marriage for women in the medieval period also includes its shadow side, the experiences that were not about love or partnership or even functional negotiation, but about the much darker possibilities that a system with so little protection for women could produce. The medieval church had rules about that too, and those rules, what was permitted, what was forbidden, and what happened when the line between the two was crossed, tell a story that is more complicated and more important than most people realize.
That's exactly where we're headed next. So get comfortable. We're not done yet.
There is a category of historical fact that when you first encounter it makes you stop and read the sentence twice, not because it's gruesome or tragic, though some of what we're about to discuss carries real weight, but because it's so specific, so matter-of-fact, so thoroughly documented that it forces you to confront just how completely the medieval church inserted itself into every corner of a married woman's life, including, and I say this with full awareness that we're in polite bedtime story territory, the bedroom. So, deep breath. Let's talk about what the church had to say about the intimate lives of married couples, because it had a great deal to say, and some of it is so extraordinarily detailed that I genuinely could not make it up. To understand this part of medieval marriage, you have to understand something about how the Catholic Church of this period understood the human body and its appetites. The Church was, to put it gently, deeply suspicious of pleasure, not just sexual pleasure, pleasure in general. The idea that a person might do something purely because it felt good with no higher purpose attached was viewed with considerable theological unease. Sex, in particular, occupied a strange and uncomfortable position in church teaching. On one hand, the church had definitively declared marriage a sacrament, a holy institution reflecting divine love. On the other, the physical act at the center of that institution was associated in the writings of enormously influential theologians like St. Augustine of Hippo and later Thomas Aquinas with the messy, uncontrollable nature of human desire. The body's appetites were exactly the sort of thing a good Christian was supposed to be working to transcend. And so the church arrived at a position that managed to be simultaneously permissive and extraordinarily restrictive. Sex within marriage was acceptable, indeed necessary, but only when approached with the right intentions, at the right times, and in the right manner. Any deviation from these conditions introduced sin into what was supposed to be a holy act. What followed from this position was a set of rules so specific, so granular, so deeply embedded in the daily rhythm of medieval life that they amounted to an entire theology of the marital bed. Let's start with the question of when.
The medieval church maintained a religious calendar full of what were called chaste periods, times during which married couples were expected to abstain from relations entirely. These were not vague suggestions. They were, at least in the earlier medieval period, treated as genuine obligations. The 6 weeks of Lent, the 40-day fast before Easter, were a period of complete abstinence. The season of Advent, the 4 weeks before Christmas, similarly demanded continence. Major feast days throughout the year were off limits. Sundays, the Lord's Day, were to be kept holy, which meant, in the stricter interpretation, free from the carnal distraction of marital relations. Some penitential traditions also excluded Saturdays, Thursdays, and Fridays from permissible activity. And then, on top of all of that, a wife was expected to abstain during menstruation, which medieval medicine regarded with considerable alarm, considering it somehow toxic or ritually contaminating. Abstinence was also required during pregnancy and for 40 days after the birth of a son, or 66 days after the birth of a daughter. I let you sit with that discrepancy for a moment. 66 days for a daughter, 40 for a son. The penitential of Cume, An early medieval text specified these numbers precisely because apparently the degree of post-birth ritual impurity a woman carried was directly related to the gender of the child she had just delivered, which is the kind of theological detail that makes you set the book down and stare at the ceiling for a while. If you add up all the days excluded by these various restrictions, historians have calculated that a strictly observant medieval couple, one following all the rules, would have had access to each other for fewer than 180 days per year, roughly half the year or less, and often considerably less depending on the individual calendar of feast days. And this was inside marriage, the only context in which the Church considered any of this acceptable at all. Now, and this is the part where it gets genuinely strange, at the exact same time the Church was imposing all of these restrictions, it was also insisting on something called the conjugal debt.
The conjugal debt was a concept rooted in the writing of the Apostle Paul, who had argued that in his letter to the Corinthians that husbands and wives owed each other their bodies. Neither partner, Paul wrote, had authority over their own body independently. Each belonged to the other. From this theological foundation, medieval canon lawyers built an elaborate doctrine. Each spouse was obligated to be sexually available to the other on request. To refuse without a legitimate reason was not merely unkind. It was, in the Church's view, a violation of a sacred obligation. It was a sin. And here is where it becomes genuinely interesting from the perspective of women's history. Because the conjugal debt was, in its theoretical formulation, entirely mutual, it applied equally to husbands and wives. Medieval theologians and canonists were actually quite explicit about this. The obligation of the conjugal debt was one of the very few areas of medieval law in which women were declared to have equal standing with men. A wife had the right to request the conjugal debt from her husband, and he was obligated to render it. He could not simply refuse. He could not claim he was tired or uninterested or had already fulfilled the obligation earlier that week. If she asked, he was required to respond. This sounds, on the surface, like a remarkable form of protection, and in a limited sense it was. There are documented cases in ecclesiastical courts of women bringing complaints that their husbands had refused to fulfill the conjugal debt and having those complaints taken seriously by church authorities. But here is where I want to invite you to think carefully, because the reality of this equality was considerably more complicated than it appeared. Thomas Aquinas, writing in the 13th century, grappled with precisely this question. In his Summa Theologica, he concluded that while the conjugal debt applied in principle to both spouses, the practical expression of it was not symmetric. He noted that a husband was expected to be attentive to his wife's unexpressed desires, to watch for indirect signs that she might want intimacy but was too modest to ask directly. Men were expected to be forthright in seeking marital relations, while women, given their natural modesty, might need their desire to be perceived and responded to rather than stated aloud. This is already operating on some fairly troubling assumptions about what natural modesty means and who gets to define it. But it went further. Other moralists of the period added additional complications that limited a wife's practical access to the conjugal debt. If a husband had already rendered the debt once and was exhausted, the wife was not permitted to request it a second time. If she did, she was, in the language of one commentary, behaving like a prostitute. Let me be precise about what that means. A wife who requested intimacy from her own husband after he had already satisfied the obligation once was characterized using the most demeaning language available.
The equality of the conjugal debt, in practice, consistently bent toward the husband's convenience. Women's needs were acknowledged in theory. In practice, they were hedged, qualified, and frequently subordinated to assumptions about feminine passivity and male prerogative. There was also the question of what the intimacy was actually for. The Church's position, maintained with considerable firmness throughout the medieval period, was that the only fully acceptable purpose of marital relations was procreation. A husband and wife who engaged for any other reason, pleasure, affection, simply because they wanted to, were committing at minimum a venial sin. The act might be technically licit, occurring within marriage, but the motivation colored it. Thomas Aquinas put it in terms that are, depending on your perspective, either admirably logical or deeply unsettling. A man who was excessively passionate toward his own wife was treating her as he would a prostitute, the implication being that desire itself, desire directed at your own spouse in your own marriage, was a form of moral failure if it was not properly ordered toward procreation. Saint Jerome, writing in the 4th century, had put it even more boldly. A man who is too passionately in love with his wife is an adulterer.
These words were repeated, quoted, and built upon for centuries. They shaped the framework within which medieval people were supposed to understand their own intimate lives. They were taught in sermons. They were asked about in confession. They were part of the moral atmosphere in which every married woman, whether she was a noble countess or a farmer's wife, was expected to understand her own body and its place in her marriage. Now, I want to be genuinely fair here, because history is not served by oversimplification. First, most historians who have studied this period believe that the vast majority of ordinary medieval people simply ignored these rules. The Church's extraordinary specificity about what was and was not permitted suggests an institution that was repeatedly confronting the gap between its expectations and actual human behavior. You do not write detailed penitential guidelines about every conceivable variation of marital sin if everyone is following the basic framework. The rules are elaborate precisely because people were not following them. Second, by the 12th century, the Church itself was softening its position. The stricter penitentials of the early medieval period, with their lists of forbidden days and detailed calculations of when relations were and were not permitted, gradually gave way to a more pastoral approach. The Church began to frame its expectations about holy days as strongly encouraged recommendations rather than absolute commands. The framework relaxed, even if the underlying theology did not fully resolve its contradictions. Third, alongside the restrictive theology, there ran a counter-tradition in medical writing, in popular literature, in the secular culture of the time that took a far more relaxed and sometimes celebratory view of marital intimacy. Medieval literature is actually full of frank, often comic, occasionally rather explicit treatments of the subject that bear little resemblance to the Church's official position. People have always been people. That part, at least, has never changed. What I find genuinely worth sitting with, though, is the existence of these rules reveals how the medieval Church conceived of women within marriage. At every level of this framework, the restrictions on when, the doctrine of the conjugal debt, the insistence on procreation as the only legitimate purpose, women occupied a deeply ambiguous position. On one hand, they were declared to have equal rights within the conjugal relationship. On the other, those rights were consistently interpreted, qualified, and applied in ways that centered male experience and male convenience.
Their own desires were acknowledged and then immediately characterized as shameful if expressed too directly. Their bodies were subject to cycles of ritual impurity that the Church's rules reflected with detailed precision. Their role in the intimate life of their marriage was simultaneously important, essential even, and almost completely outside their own control. A woman did not choose when she could have relations with her husband. The calendar chose, the Church chose, the husband's state of exhaustion chose. The question of whether she had just given birth to a son or a daughter chose. She was once again the person at the center of something she did not design and could not fully direct. And yet, and this is the observation that keeps bringing me back to this period, medieval women were not passive. They were not simply accepting recipients of whatever the system dictated. The evidence from church court records, from medical texts, from private correspondence and household accounts suggests women who were actively navigating all of this, pushing back where they could, claiming the conjugal debt when it served their interests, using the Church's own framework to argue for their rights in contested situations. The system was not built for them, but many of them learned to work it with considerable skill. Which brings us naturally to the question of what happened when the system broke down entirely, when the marriage itself became the source of the problem rather than the solution, when a woman found herself inside a marriage that was, in various ways, destroying her, and discovered that the same institution that had constructed the entire edifice of marriage law had also built a set of walls around it that made leaving almost impossible.
The medieval Church had definitive views on divorce. And those views, the extreme difficulty of ending a marriage, the narrow paths through which a woman might legally seek relief, and the price she paid for attempting to use them, are some of the most revealing and, honestly, some of the most heartbreaking things we'll encounter in this entire series. Let me tell you about a woman named Joan Wood. The year is 1519, London, a city of narrow streets, crowded alehouses, bell towers, and the constant noise of a medieval metropolis going about its daily business. Joan is somewhere in the tangle of streets just north of London Bridge when she sees her opportunity. A brief moment when she is not being watched, not being followed, not under the immediate eye of the man she has been living in terror of. She finds a parish beadle, one of the local officers charged with keeping the peace, and she says to him, with whatever composure she can manage, "Yonder is my husband in the church, and I dare not go home, for he will kill me." She asks the beadle to walk her to her daughter's house in Bermondsey, across the river to the southeast, not far in distance, but in a city where a woman could not simply leave her husband's house without his permission, and where returning to a violent spouse was the legal expectation. It might as well have been another country. The beadle, Thomas West, agreed to help. They set off together. They did not get very far. Joan's husband intercepted them in the street. He pulled out a knife. Thomas West managed to disarm him, and that knife was later brought into court as physical evidence in Joan's legal suit for separation, proof held in someone's hands in a courtroom of what she had been living with.
Joan Wood's case survives in the records of the London Consistory Court. It is one of dozens, hundreds of documented stories from medieval England of women trying to escape marriages that were destroying them. And what those records revealed, the specificity of them, the detail of individual lives preserved in legal Latin while the women themselves had no voice in any other public record, is one of the most important and most harrowing parts of the entire history of medieval marriage. The medieval church, which had constructed the entire legal architecture of marriage, was also the institution responsible for governing what happened when that architecture failed. And its answer to the question of what a woman could do in a marriage that had become unbearable was deeply, systematically inadequate. Divorce, in the modern sense, a legal ending of a valid marriage that allowed both parties to remarry, did not exist. The Church's position, based on its reading of Scripture, was that what God had joined together, no human court could lawfully put asunder. A valid marriage was permanent. It ended at death and not before. What the Church offered instead were two very different things, and it's worth understanding both clearly, because they affected women in entirely different ways. The first was annulment, what medieval canon lawyers called the divorce from the bond of marriage, or in the Latin they preferred, divortium ab vinculo matrimonii. An annulment was not the ending of a marriage. It was a declaration that a valid marriage had never existed in the first place. This sounds like a fine distinction, but it had enormous practical consequences. An annulment wiped the slate clean. Both parties were free to remarry. The problem was that the grounds for annulment were extremely narrow. The marriage had to have been invalid from the very beginning, typically because of coerced consent, because the parties were too closely related by blood, because one party had been previously married to someone else, or because the marriage had never been consummated due to physical incapacity. These grounds were sometimes used creatively.
Consanguinity, the blood relationship prohibition, was the most commonly exploited in the medieval period. The Church prohibited marriage between anyone related within 7 degrees, which, in practice, meant anyone who shared a common ancestor going back 7 generations. For the aristocracy, who tended to intermarry within a relatively small pool of noble families, this meant that almost any 2 noble people could likely find some common ancestor if they looked hard enough. An unhappy marriage could sometimes be dissolved by the convenient discovery, real or constructed, that the couple were distant cousins. The case of Lothar II, ruler of Lotharingia in the 9th century, is a particularly vivid illustration of how this worked, and, more importantly, of how it worked very differently for men than for women. Lothar had been married to a woman named Teutberga. The marriage was childless, which was politically disastrous for a ruler who needed an heir. Lothar had a mistress, a woman named Waldrada, who had already borne him children. He wanted out of his marriage. He wanted to marry Waldrada instead. What followed was a protracted, public, and ultimately unsuccessful campaign spanning decades. Lothar accused Teutberga of the most serious charges he could construct. He assembled councils of bishops to hear his case. He pressured, manipulated, and exhausted every legal avenue available to him. And Teutberga, who had done nothing wrong, fought back at every step. She appealed to the Pope. She refused to go quietly. She persisted. Eventually, the Pope sided with Teutberga. Lothar did not get his annulment. He died before the situation was resolved, still married to a woman he had spent years trying to be rid of, which is, depending on your perspective, either a satisfying outcome or just a very long, exhausting one for everyone involved. Now, here's the point I want to make about this case. Lothair was a king. He had access to bishops, councils, the ear of powerful churchmen across the continent.
He had virtually unlimited resources to pursue his legal campaign. He had every structural advantage available to a medieval man of his rank, and he still could not force an annulment. For an ordinary woman, with no political connections, no independent financial resources, and no legal identity separate from the husband she was trying to escape, the obstacles were proportionally enormous. If a king couldn't make the system bend to his will when he wanted out, imagine what it looked like for everyone else. Which brings us to the second option the Church offered: the separation from bed and board, or divortium a mensa et toro in Latin. This was not a dissolution of the marriage. It was permission for the couple to live apart. They remained legally married. Neither party could remarry during the other's lifetime, but a woman granted this separation was allowed to establish her own household and live outside her husband's roof. The grounds for this were somewhat broader than for annulment. The most commonly cited were adultery, heresy, or cruelty, what the Church called saevitia in its legal Latin, a word meaning severity or brutality. And this is where we return to Joan Wood and to Agnes Corby and to the thousands of women whose names appear in the consistory court records of medieval England. Because cruelty was, in practice, the ground on which almost all known separation cases were brought. But the threshold for what qualified as sufficient cruelty was extraordinarily high. The phrase that appears repeatedly in the legal records, in the standard Latin formula used in these cases, translates roughly as "she does not dare to cohabit with her husband." She does not dare, not that she is unhappy, not that he has been unkind, but that the level of physical danger is such that her life is at genuine risk. Historians studying the records of the ecclesiastical province of York from the 14th to the early 16th centuries have identified only 6 identifiable applications for separation on grounds of cruelty for an entire region over more than a century. 6. Not because violence was rare in medieval marriages, the records make clear it was not, but because the legal threshold was so high, the process so costly, and the outcome so uncertain that most women never got as far as a formal petition. And here is the layer that I find most devastating of all. Even when a woman managed to bring a case, even when she had witnesses, even when she had physical evidence, a knife brought into court by a sympathetic beadle, testimony from servants who had watched her husband's escalating violence, the church courts were not primarily interested in helping her escape. They were primarily interested in reconciling the couple. The institutional goal was the preservation of the marriage. The woman's safety was a secondary concern. The court might order the husband to post bonds guaranteeing his future good behavior. It might reprimand him. In serious cases, it might finally grant the separation she sought. But the default, the preferred outcome, was always reconciliation.
Go back. Try again. Your souls are joined before God. What this meant in practice was that a woman petitioning for separation had to prove not merely that violence had occurred, but that the violence had been so extreme, so repeated, so escalating, that no hope of safe cohabitation remained.
She had to paint a picture of her situation that left the court no reasonable option but to accept that returning her to that household was effectively sentencing her to serious harm. And she had to do this without money, without independent legal standing, often without the ability to appear in court herself except through a representative. And if the court decided her case had not met the threshold, she had to go home. There is another dimension to this that deserves direct attention, because it has been debated and sometimes misunderstood in popular history. The idea that medieval law allowed a husband to beat his wife within certain limits, specifically that he could use a stick no wider than his thumb, which supposedly gives us the phrase rule of thumb, is one of those historical claims that turns out to be more complicated than it sounds. The rule of thumb as a specific legal doctrine is actually contested by historians. Some researchers have found no consistent medieval legal text that specifies the thumb measurement as a formal rule. Others argue the phrase's etymology has nothing to do with domestic violence at all. What is documented clearly and consistently is the broader principle that a husband had the moral and legal authority to correct his wife through physical means, provided that correction was aimed at governance rather than cruelty, and provided it did not rise to the level of endangering her life. This is a distinction that functioned entirely differently depending on who was drawing the line. The Church's position was that correction within the household, including physical correction, was analogous to the authority of a father over a child or a master over an apprentice. It was considered a form of moral responsibility. A 15th century text, sometimes called the Rules of Marriage, exhorted the husband to stand as judge over his wife. When she committed an offense, he was first to admonish her sharply. If that failed, he might need to frighten her more forcefully, and if that still failed, the text suggests, with a clarity that is difficult to read across 5 centuries, a stick might be required. Because it argues it is better to punish the body and correct the soul than to let the soul be corrupted through leniency. These ideas were not marginal. They were taught from pulpits. They were embedded in household manuals. They shaped the expectations that ordinary people, both men and women, brought to the institution of marriage. And yet, as with everything in this history, the reality was more complicated than the official position. Social disapproval of excessive violence toward wives was real and documented. When John Wright beat his wife Elizabeth in a neighborhood alehouse in 1521, stripping her to her petticoat in front of witnesses, the innkeeper told him to take her and leave. He didn't intervene more forcefully because challenging a neighbor's authority over his own household carried its own social and legal risks. But the act of expulsion was itself a statement. This behavior was not acceptable in public. Agnes Corby's servants witnessed her husband's violence and eventually testified to it in court. Joan Wood's neighbors knew what she was living with before she made her desperate walk with the beetle toward Bermondsey. The records suggest a community that had a rough, imperfect, but consistently applied sense of where the line was. Governance was acceptable. What looked like uncontrolled rage, what appeared to cross from discipline into something darker, attracted intervention, gossip, community pressure. Not reliably, not in ways that protected women consistently, but the line existed in social practice even when the law drew it very differently. I want to sit with one more thing before we move on, because it connects to everything we've been discussing and points towards something important. The women in these records, Joan Wood, Agnes Corby, the dozens of women whose names appear in the York consistory court cases and the London records, were not passive. They were not simply enduring. They were doing something active, difficult, and often dangerous. They were using every resource available to them to change their situations.
They found allies, beadles, sympathetic neighbors, servants willing to testify. They navigated legal systems that were not designed to help them. They abandoned their husbands informally and moved to new neighborhoods when the formal legal process was inaccessible. They used the language the court required, the specific formula of "she does not dare to cohabit," because they understood that language was the tool they had. They were working the edges of the system they were trapped in with the skill and determination of people who had no other options and understood the stakes perfectly. This is not a story about helplessness. It's a story of constrained agency, about what people do when the structures around them are built against their interests and they act anyway. What strikes me deeply about this particular corner of medieval history is how far it reverberates forward. The idea that a woman needed to prove danger before she could be legally separated from a man harming her. The institutional preference for reconciliation over safety. The gap between what the law permitted as correction and what the community recognized as cruelty. These are not only medieval problems, they echoed in different forms through the centuries that followed. And understanding where they came from, the specific theological and legal frameworks that built them, matters. Because nothing changes without first being named. So, we've spent a long time now in the harder corners of this story, and I think it's time to turn towards something different. Because the history of what marriage meant for medieval women is not only a story of constraint and harm, it's also a story of remarkable women who found ways to operate within this system that gave them genuine power, who took what the world offered and turned it into something that commanded real respect, real influence, and sometimes real authority. The most unexpected source of that authority, and the one most people never think about when they imagine the medieval period, is also the one we're going to explore next. It involves grief and loss, and a strange kind of liberation that the system never quite intended to create.
In most times and most places in history, losing a husband was a catastrophe. A woman wept, mourned, dressed in black, and faced a world that had been structured around his presence, his name, his income, his legal identity, his decisions. Everything that had organized her life was suddenly absent. And yet, in the medieval world, in a twist that the system never quite intended, the death of a husband was also the moment a woman was handed something she had not held since before her wedding day: her own legal self. The moment a husband died, his widow stepped out from under the doctrine of coverture. She was no longer a femme couverte, a covered woman, legally absorbed into someone else's identity. She became, in the language of medieval law, a femme sole again, a woman alone. And that phrase, which sounds lonely, actually carried extraordinary implications. She could own property, she could sign contracts, she could appear in court as an independent party, sue and be sued in her own name, write a will, and decide what happened to everything she had accumulated. She could, and this was genuinely radical, make decisions without asking anyone's permission. For many medieval women, especially those who had spent decades carefully managing their husband's estate while possessing no legal authority over it. This moment of grief was also, simultaneously, a moment of liberation unlike anything they had ever experienced. Historians who study this period have noted the paradox so often that it has become something of a touchstone in medieval women's history.
Widowhood was the most powerful legal status available to the vast majority of women in the medieval world. Not marriage, not birth, not rank or wealth or intelligence. Widowhood. And once we understand why, it becomes impossible to look at the medieval widow, that figure so often depicted in popular imagination as a frail, grieving presence in black, without entirely reconceiving her. Let's start with the basics of what widowhood actually delivered, legally and economically. We discussed the dower briefly earlier in this series, the 1/3 of a husband's land that a wife was legally entitled to receive upon his death for the rest of her own lifetime. The Magna Carta of 1215 had explicitly enshrined this right. No widow should be compelled to pay anything for her dower, nor should she be delayed in receiving it. These were among the first formal legal protections for women in English history, embedded in one of the foundational documents of Western law. 1/3 of everything her husband had held during their marriage, not a portion of what he left in his will, not what his heirs decided to give her out of generosity, 1/3 by legal right for life. In addition, a widow was entitled to remain in her husband's principal residence for 40 days after his death, what the law called her quarantine, while the legal and financial arrangements were being settled. In some urban settings, particularly London, widows had even more generous protections, with the right to remain in the family home until they remarried or died. And then, if the couple had established a jointure at the time of their marriage, those jointly held properties we discussed earlier in the context of marriage negotiations, the widow took full control of those as well, immediately upon death, without contest. The total picture for a woman who had married well and outlived her husband could be remarkable. Margaret de Lacy, Countess of Lincoln, who was widowed in the 13th century, held control of 1/3 of the Lacy family lands and 1/3 of the Marshall estate simultaneously. She received whole counties as part of her dower settlement. When her eldest son died in 1258, she managed the entire estate until the younger heirs came to age. One woman controlling lands spread across multiple English counties, answering to no one. Then there is Margaret de Brotherton, whom historians sometimes describe as one of the most formidable widows of the 14th century. She had been married twice, first to John Lord Seagrave, and then to Sir Walter Mauny. Each marriage had brought its own dower and jointure. Each husband's death had added to the total. And Margaret, who combined longevity with considerable political ambition, watched those assets accumulate across decades. By the 1990s, the income from her landholdings reached £3,000 per year. That is a sum that placed her among the wealthiest individuals in England. Full stop. Not the wealthiest women, the wealthiest individuals. She styled herself the Countess Marshall, after one of the great historic offices of state. The Crown addressed her as Margaret Marshall. She wielded her wealth and connections with the focused intention of someone who had spent years watching power operate from the outside and now had a chance to participate directly. She was, in the most literal sense, one of the most powerful people in the country. And she had reached that position through the specific legal mechanism that widowhood created: the accumulation of dower rights from successive marriages, combined with the simple fact of outliving the men she had married. Now, I want to be careful here, because the story of the powerful medieval widow has a shadow side that's equally important to understand. The legal freedoms that widowhood conferred were real, but they were not universally accessible, and they were not unchallenged. For a woman of wealth with established social connections and the means to fight for her rights in court, widowhood could indeed be transformative. But for women of more modest circumstances, the same moment that delivered legal freedom also delivered economic vulnerability.
A farm widow whose husband had done most of the heavy physical labor, whose young children were too small to help, who owed rent to a lord and had no surplus to carry her through the winter, for her widowhood was not liberation, it was crisis. Historians studying medieval manor records have found that poor widows in the English countryside frequently remarried quickly, not from any emotional desire for companionship, but from economic necessity. The household economy of a medieval farm required labor to function, and a widow who could not provide it herself had to find someone who could. Remarriage was often the most rational available response to an essentially impossible situation. And even wealthy widows faced pressures that complicated the simple picture of freedom. The most common and most immediate was the pressure to remarry, applied by lords, by family members, by the social expectation that a woman without a husband was an incomplete or potentially dangerous figure. Under Anglo-Norman and early Angevin kings, widows of men who held land from the crown were explicitly in the gift of the king. This means exactly what it sounds like. The right to grant or withhold permission for a widow to remarry belonged to the monarch, and that right was treated as a form of property. Kings sold it. They rewarded loyal allies with it. An ambitious baron who wanted to add to his estates might pay the crown for the right to marry a specific widow, meaning the widow's hand in remarriage became a commodity that was bought and sold without any direct reference to her own preferences. The Magna Carta, which enshrined dower rights, also addressed this. It stated explicitly that a widow should not be compelled to marry if she wished to remain single, provided she paid a fee to the crown to purchase that freedom. She had to buy the right not to be sold again. Think about that for a moment.
A woman outlived her husband. She gained legal freedom, financial independence, the ability to direct her own life for the first time. And then the system reached out and said, if you want to keep that freedom, you must pay for it. Your independence has a price tag. Some women paid it gladly. Some could not afford to. And some were simply not given the option, finding themselves given in remarriage to men they did not choose before they had time to establish themselves in their new legal status. There is a particularly fascinating wrinkle in this story that illuminates how complex the medieval widow's position really was. When a wealthy widow did choose to remarry, of her own volition, to a man she selected, there was a category of contemporary opinion that viewed such a marriage with deep suspicion. The phrase that some medieval writers used for a widow who had married more than twice, or who had made a poor match, or who had used her wealth to marry a man of lower status, was startling in its directness. Matrimonium diabolicum, a devilish marriage. The concern was partly social. A widow who married down was considered to be misusing her position, degrading her family's standing. But there was also something else underneath it. A wealthy widow who remarried on her own terms had, in some fundamental sense, found a way to operate the system for her own benefit. She had accumulated property through successive marriages, held it during her widowhoods, and then deployed it strategically in a subsequent relationship of her own choosing. She was playing the game that men had always played, using the same rules, and winning. And that, apparently, made people deeply uncomfortable. Let me introduce you to a woman whose story captures the daily texture of powerful widowhood in the medieval period more vividly than almost anyone else I've encountered. Her name was Alice de Breen. She was a gentlewoman, not royal, not of the highest nobility, but solidly comfortable and well-connected. She lived at Acton Hall in Suffolk, England. She was widowed in 1386 and never remarried. She lived as a widow for nearly 50 years until her death in 1435. What makes Alice remarkable is not that she was a famous figure in her own time. She was not. But she kept records, extraordinarily detailed records. The household accounts she maintained between October 1412 and September 1413 have survived intact, and they offer a window into the life of a medieval widow that is genuinely unlike anything else in the historical record. Those accounts document everything: every meal served, every guest received, every quantity of grain, every piece of livestock, every expenditure of her substantial household. In a single year, hundreds of guests passed through Acton Hall. Alice negotiated marriages for her daughters, corresponded with the king about the wardships of noble children being raised in her home, managed multiple estates spread across several counties, and appeared in court to enforce her legal rights against those who challenged them, including, in one documented case, having a man sent to debtor's prison for failing to pay what he owed her. She sent men to prison. She corresponded with kings. She ran a household that functioned as a social, economic, and administrative hub for her entire region of England. And she did all of this while being legally categorized as a widow, a status that gave her the authority to act that marriage had withheld. The household account that survives from 1412 to 1413 is a single year. 50 years of Alice's widowhood are represented by this one surviving document, and even from this single year, historians have been able to reconstruct the full complexity of a life that was, by any measure, richly active, deliberately managed, and thoroughly autonomous.
I think about women like Alice de Breen when the broader narrative of medieval women's constraint threatens to become too simple. Because the constraint was real. We've spent a long time in this series documenting it carefully. But so was the agency, so was the competence, so was the life. These were not women waiting for history to happen to them. They were making it, quietly, in account books and court petitions and letters to kings, in the 10,000 small decisions that kept households running and estates intact and families fed and futures secured. The medieval world did not build its systems for them, but they lived in it anyway, and some of them, against odds that are genuinely difficult to fully imagine from where we sit tonight, found ways to make it work. That is where we'll rest for now. If you're still with me, still comfortable, still somewhere quiet and warm, thank you. We've covered a remarkable amount of ground tonight. The childhood that wasn't a childhood. The negotiations that determined a woman's entire future. The law that made her disappear on her wedding day. The church that legislated the most intimate corners of her life. The courts that sent her home when she asked for help. And the strange accidental freedom that grief sometimes brought. There's still more to explore in this world. More women, more stories, more of those moments where the system cracked just enough to let something remarkable through. But for now, let this settle. Let the weight of it and the wonder of it rest alongside you as you drift. These women lived. They mattered. And they deserve to be remembered not as victims of their time, but as the extraordinarily capable, endlessly resourceful, quietly determined people that the evidence, when you look closely enough, consistently reveals them to have been. Sleep well. Let's stay a little longer in the world of medieval widows, because the stories there are genuinely remarkable, and I think they deserve more time than we've given them so far. We've talked about the legal framework of widowhood, the dower rights, the pressures to remarry, and the strange double-edged freedom that losing a husband could bring. But I want to sit with the human reality of it for a while, because this is where the history gets vivid in a way that the legal documents and court records can only hint at. Consider for a moment the question of what a widow actually did with her days. Now, I know that's a deceptively simple question, but think about it. A woman who had spent her married life managing a household, raising children, overseeing servants and tenants and livestock and stores of grain and all the 1,000 details that kept a medieval estate running, suddenly found herself with no husband, no lord, no male authority figure telling her what to do. And instead of the empty, purposeless existence that widowhood is sometimes imagined to have been, what the records show is women who threw themselves into their independence with a kind of fierce, practical energy that is genuinely inspiring to read about. Take Margaret de Lacy again, because her story has a quality that makes it impossible to look away from. She was born in the early 12th century, the daughter of one of the most powerful families in England. She married twice, first to John de Lacy, who became Earl of Lincoln, and then, after his death and a brief period of widowhood that she apparently enjoyed enormously, to Simon de Kyme. Both marriages brought substantial dower lands. Both husbands died before she did, and Margaret, who seems to have been constitutionally incapable of sitting quietly while anyone else managed anything, simply absorbed the estate. When her son from her first marriage died in 1258, leaving only a young daughter, Margaret stepped in to manage the entire martial inheritance until her grandson came to age. We're talking about one of the greatest earldoms in England, land that stretched across multiple counties, castles, revenues, armies of tenants who owed military service to her grandson, and for years it was Margaret de Lacy who made the decisions.
She issued charters. She settled disputes. She corresponded with the king. She granted permissions and revoked them. She was, by any definition, one of the most powerful people in England during that period. And she got there by outliving 2 husbands and refusing to let anyone else take what was rightfully hers. Now, the question I always come back to with Margaret is what she thought about all of it. What did it feel like to finally be free after a lifetime of legal invisibility? Did she feel triumph? Relief? A quiet, fierce satisfaction at finally being seen as a person in her own right? We don't know. The records don't tell us what she felt. They only tell us what she did, and what she did was remarkable. But I want to balance these stories of powerful widows with something a little more complicated, because the medieval widow's experience was not a uniform one, and pretending otherwise would be doing a disservice to the women who lived through harder versions of it. Consider the matter of what historians have called the widow's chamber. This was a custom particularly prevalent in London and other urban centers, where a widow was entitled to what was called her widow's chamber. It was a portion of the household goods, the personal possessions that had belonged to her marriage, her clothes, her jewelry, the items of everyday life that she had used and accumulated. The idea was that these were hers by custom, separate from the formal dower, a recognition of her role in building the household alongside her husband. The problem was that the widow's chamber was governed by custom rather than law, which meant it had to be negotiated after every death. And in those negotiations, widows frequently found themselves at a disadvantage. The husband's family might dispute what she was entitled to. The executors might claim certain items for the estate. The custom that protected her in theory became in practice one more arena of conflict that required energy and often money to navigate.
There are records of widows in London in the 14th and 15th centuries fighting for months, sometimes years, over the contents of their own homes. Not the dower lands, not the estates, not the formal legal framework, just their clothes, their jewelry, the bed they had slept in, the pots and pans they had cooked with, the very objects of their daily life, suddenly called into question the moment their husband was in the ground. And here's the part that I find particularly revealing. In many of these cases, the widows won. Not always, not easily, but the records show women who petitioned, who appeared in court, who produced witnesses to testify to their contributions to the household, who argued their cases with a determination that suggests they understood very clearly what was at stake. They were not passive recipients of whatever the system chose to give them. They were advocates for themselves, operating in the spaces the system left open, pushing against the boundaries of what was customary, building case by case the precedent that would protect the women who came after them. This is the kind of history that rarely gets told, not the grand narratives of powerful countesses and their political maneuvering, but the quieter, more ordinary persistence of women who simply refused to be erased, even in grief, even when the cards were stacked against them. Now, let me take us somewhere different for a moment, because we've spent a lot of time talking about law and property and the formal structures of medieval marriage, and those things matter, but I want to step back and ask a different question. What was the actual texture of daily life for a married woman in the medieval period? What did her days look like? What did she eat? What did she worry about? What gave her joy? The answers to these questions are harder to find than you might expect, because the records that survive from the medieval period are overwhelmingly the records of men, legal documents, court records, property transfers, correspondence between nobles, chronicles written by monks. In almost none of these sources is there a sustained attention to what women's daily lives actually looked like from the inside.
But the records that do survive, when gathered together and read carefully, begin to reveal something. And what they reveal is that married women in the medieval period were extraordinarily busy. I want to give you a sense of this by describing what historians have been able to reconstruct about the household of a medieval gentlewoman. Not a queen, not a countess, just a reasonably well-off married woman somewhere in 14th or 15th century England. Her day would have begun early, before dawn probably. She would have overseen the lighting of fires, the preparation of food, the feeding of any livestock kept within the household compound. She would have managed the servants, assigning tasks, resolving disputes, ensuring that everything ran on schedule. She would have overseen the brewing of ale, which was an essential part of every medieval household's daily operations. She would have managed stores of food, planned meals, accounted for guests who might arrive unannounced, which was a constant possibility in a world where hospitality was both a social obligation and a practical necessity. She would have managed clothing, not just her own, but her husband's, her children's, the servants', the household's linens and textiles, and the raw materials for making and mending all of it. In a world before ready-made clothing, before shopping, before any of the infrastructure we take for granted, this was an enormous undertaking. Cloth had to be acquired, sometimes woven in the household itself, cut, sewn, maintained, repaired, and for a large household, this was a year-round operation that required constant attention. She would have been involved in what we might broadly call financial management, keeping track of what came in and what went out, managing the poultry yard, the dairy, the garden that produced vegetables for the table, overseeing the collection of rents from any tenants on the family's land, managing the paid workers, the seasonal laborers, the various servants who kept the whole operation functioning. And this was all before she had children. Once children entered the picture, their care and education and eventual placement in the world became another set of responsibilities that fell primarily to her.
What I'm describing is not a life of leisure. It is not the image of a medieval lady languishing in a castle while servants did everything. It is a life of relentless, complex, demanding work. Work that required intelligence and organizational skill and an enormous amount of time and energy. Work that was, crucially, invisible in the official records, because the records were concerned with property and law and the actions of men, and not with the daily operations of a household that kept everyone fed and clothed and functioning. The medieval married woman was, in effect, the chief operating officer of a small enterprise that ran around the clock 7 days a week with no weekends and no vacation and no retirement. And she did all of this with no legal identity of her own, no property she could claim as hers, no wages for her labor, no voice in the legal or political structures that governed her world. But she did it anyway, every day, for the entirety of her married life. I want to stay with the question of children for a moment, because it's one that I think about a lot when I'm reading about medieval women's lives. Medieval medicine had no understanding of germ theory, no antibiotics, no vaccines, no really effective treatments for most childhood diseases. The result was that childhood mortality in this period was staggering. Somewhere between 1/3 and 1/2 of all children born in medieval England died before reaching adulthood. This was not a reflection of neglect or poor parenting. It was simply the world they lived in. Disease was an omnipresent threat, and children's immune systems were, like everyone's, completely unprepared for the microbial world they had been born into.
For a medieval woman who bore children, this meant a lifetime of pregnancy and childbirth and nursing and child care, set against the constant, looming possibility that any of those children might die. And children died often, at every stage, in infancy from disease and malnutrition, in childhood from accidents and infections, in adolescence from the same hazards that threatened adults. The emotional toll of this, I think, is almost impossible to fully imagine. But the records give us glimpses. Letters that mothers wrote about dead children, brief mentions in wills and household accounts of mourning periods, the careful notation of which of a woman's children had survived and which had not. These small, factual entries in documents that were not primarily concerned with emotion nonetheless carry the weight of lives marked by loss. And yet, women continued to have children. They continued to raise them. They continued to invest enormous amounts of love and energy and hope in their futures, because that was what people did. That was what life required. The medieval world was no more fatalistic about death than any other time. People grieved, people mourned, people continued. There's a passage in a medieval text that I've always found particularly poignant. It describes a noblewoman visiting her daughter's grave years after the girl had died in childhood. The woman is described as kneeling at the grave and weeping, and then rising and returning to her duties. The image has always struck me as capturing something essential about the medieval experience of grief. It was not that grief was ignored or dismissed. It was that life continued alongside it, that the living had to keep living even when the dead were not forgotten. Now, let me bring us to something a little different, because one of the things I've been thinking about as we've gone through this material is the question of how we know what we know, where these stories come from, why some women have come to us in detail while others are entirely lost. The honest answer is that medieval women's voices are rare, not because women didn't exist or didn't do remarkable things, but because the systems that preserved records were systems built and operated by men, and those systems were primarily concerned with the things men cared about: property, lineage, political alliances, military obligations, church offices, the movements of kings and nobles and armies.
Women appear in these records in specific, defined ways. As daughters whose marriages transferred property. As widows whose dower rights needed to be recorded. As occasionally disruptive forces in inheritance disputes. As saints sometimes. As sinners. As rare exceptions to the general rule that the people making and keeping records were men. But the texture of ordinary women's lives, the details of what they thought and felt and worried about and hoped for in their daily existence, these things are almost entirely absent from the written record. And this is not unique to the medieval period. It's a problem that runs through all of history, into the early modern period, into the 19th century, even into the 20th. The further back you go, the thinner the evidence becomes. Not because women weren't there, but because the mechanisms for recording their experiences were not designed to capture them. What this means is that the women we can see most clearly in the historical record tend to be the exceptions: queens and nobles, and saints and sinners, women whose status or behavior or circumstances made them visible to the record keepers of their time. The ordinary woman, the peasant's wife, the merchant's widow, the farmer's daughter, she is largely lost to us. We can infer things about her life from the records that do survive, but her voice, her specific individual perspective, is almost never available. This is something I think about a lot when I'm making a series like this one. How much are we missing? What stories have we lost entirely? What would we know if the records had been kept differently, if the people writing history had been more attentive to half the population? I don't have good answers to those questions, but I think it's worth being honest about the limits of what we can know,
and not pretending that the women we can see are representative of all women in all circumstances. The truth is more complicated and more frustrating than that. That said, the women we can see are still remarkable, and I want to spend the rest of this part talking about a few more of them, because I think they deserve to be known.
Let's talk about the de Bohun family. Specifically, the women of the de Bohun family in the 13th and 14th centuries, because they offer a case study in something that I think is important for understanding medieval women's agency within constraints. The de Bohuns were a powerful English noble family, and through a combination of strategic marriages, fortunate inheritances, and sheer longevity, several women of this family ended up in possession of enormous wealth and power in their widowhoods. One of them, named also Margaret, but known as the elder Margaret de Bohun, was widowed in 1305 and lived for another 25 years. During that time, she managed estates across multiple counties, negotiated with the king, placed her children strategically, and generally conducted herself with the kind of competence and authority that suggests she had been managing things long before her husband died, and simply continued doing so without the legal impediment. But here's what I find most interesting about her. In her wills, she was meticulous about providing for her daughters in ways that gave them more control over their own lives than the standard arrangements would have allowed. She set up trusts and settlements that protected their property from the marriages their husbands might enter into. She used the legal tools available to her to try to improve the options that would be available to the women who came after her. This is not something we should take for granted. Medieval widows had no obligation to think about the futures of their daughters-in-law or stepdaughters or any other women. They had every reason to be primarily concerned with their own interests and those of their own children. But Margaret de Bohun chose to use her freedom, her wealth, her legal knowledge to try to create better conditions for women who would inherit from her. I find that genuinely moving, not because it was universal, but because it was possible. Because within even the most constrained systems, there were always spaces where something better could be built, and sometimes someone found those spaces and used them. Let me tell you about one more woman before we close this part. Her name was Catherine Swineford. You've probably heard of her because her descendants became extraordinarily important in English history. But the story of how she got there is less well known than it deserves to be.
Catherine was born in the mid-14th century, the daughter of a Lincolnshire gentleman of modest means. She entered the household of John of Gaunt, the third son of King Edward III, as a lady-in-waiting to his wife, Blanche of Lancaster. She was not noble, she was not rich. She was, by the standards of the time, essentially a servant. John of Gaunt and Catherine became involved, not as a formal marriage, because that would have been scandalous and politically impossible, but as something that was clearly understood by everyone at court. They had children together. They maintained a household together for decades, and Catherine's position, while irregular, was clearly one of genuine intimacy and partnership. When Blanche died and John eventually married his third wife, Catherine remained in his life. She was not discarded. She was not sent away. She continued to be, in every way that mattered, his partner and companion. And after John died, Catherine lived on for many years, long enough to see her daughter Joan marry Ralph Neville and produce grandchildren who would include some of the most powerful figures in 15th century England.
One of those grandchildren, through an ancestral connection that history has never quite explained, would eventually become Henry IV, the first Lancastrian king. Catherine Swynford died in 1403, a woman who had never been a queen, never been formally married to the man she loved, never been acknowledged in the official record as anything more than what she technically was. And yet her bloodline sat on the throne of England. Her descendants shaped the history of Britain for centuries. I tell her story not as a fairy tale, because it wasn't one. She lived through a great deal that was painful and uncertain and full of compromises she didn't choose. But I tell it as a reminder that the formal categories, the legal definitions, the official record, these things don't capture everything that matters. They never have.
Catherine Swynford found a way to live a life of genuine connection and influence within a system that offered her no legitimate place. And her descendants are still with us, in a sense, even now. That's worth sitting with for a moment. As we come to the close of this part, I want to return to something I said earlier. The medieval world did not build its systems for women, but women lived in it anyway. They navigated it. They negotiated it. They pushed against its edges. They built lives within it, sometimes extraordinary lives, sometimes simply ordinary lives that were still, in their own way, remarkable. The legal records that survive tell us about property and inheritance and the formal structures of power. What they can't tell us, not fully, not completely, is what it felt like to be alive in that world as a woman, what it felt like to love and grieve and hope and fear, what it felt like to be the person at the center of the system that rarely saw you as a full human being. We can infer, we can imagine, we can piece together fragments that suggest the full picture must have been something like what we would recognize, but we'll never know for certain. What we do know is that they survived, they persisted, they raised children and managed households and negotiated with lords and built networks of support, and sometimes fell in love and sometimes didn't, and lived through losses we can barely imagine and kept going anyway. That is not nothing. That is, in fact, quite a lot. Sleep well. There will be more stories waiting for you when you wake.